We have concerns with the way the judge has presented his position in the motion, actually the order setting bail. And I think the words that he used in there are concerning enough to us to file it for him and now to file it with the appellate court, and they'll make the decision. I'm not patronizing Judge Lester to say that I still think he's a great judge and a good judge and very fair, but when my client particularly reads the order granting bail and some of the suggestions that were made in that, there's a real question whether or not Judge Lester may have stepped over bounds, and my client has a very legitimate concern about that. Right now, of course, he is still the trial judge on the case. We're still moving forward with whatever we have to do or need to do with the case. But the appellate court will handle what's called this extraordinary writ as quickly as they can. So they can address it anytime they want in the next few weeks. They can ask for a response. They can handle it on their own. It's really up to them. But that is done now, and it's actually on its way to being filed right now. If I didn't think, and if my client didn't think that the order granting bail had within it evidence or suggestions that we might not get a fair hearing, we would be moving forward right now. If we win a defense or immunity self-defense hearing and the judge says that we have proven by what's called a preponderance of the evidence that he acted reasonably in using deadly force, then the charges are dismissed. You know, people look at stand your ground and they immediately think someone's standing there with deadly force, be it a gun or a weapon, and having the opportunity to back up, but not having the need to under the statute. I think the facts suggest in this case that what probably happened was my client was reacting to having his nose broken, which I think is probably undisputed that he had a broken nose now, and that he reacted to that by screaming out for help for 40 seconds, and then he got his head still hit. So he wasn't in a position, I think, where there was any suggestion that he could retreat, which he was allowed to do under the statute, was to react without retreating. But I think the facts seem to support that though we have a stand your ground immunity hearing, what this really is a simple self-defense immunity hearing. It really, I think, needs to be sort of reconstructed to be what really meets the facts. And what meet the facts are, did he act reasonably and in self-defense? He didn't have an opportunity to retreat if he was on his back. And I think that's the way we need to sort of refocus what the hearing is going to be about. So I think we're talking probably 5 months, thereabouts, 4 or 5 months, before we have everything done for a stand your ground or a self-defense immunity hearing. The money's not coming in all that strongly right now. I think that as we move forward, we're probably going to have to consider indigency for Mrs. Zimmerman unless something else happens with more donations and whatnot, and it puts it on the state's shoulders to actually fund that defense. How much pay have I received? To date, 0. From any source whatsoever, except my wife. She has been paying dearly for my work on this case, but not with money. Other than that, that's all I've gotten. I've already heard, and I'm sure you have as well, there's private investigators who believe that there's a $5,000 reward for finding out what Mr. Zimmerman is. You know, that just causes more concern for his safety. I want him safe wherever that might be. If it's out of state, so be it. I mean, I think that he has evidenced his willingness to come back when wanted and to, you know, take care of himself appropriately while on bond, so I don't think there's any concern where he is. We just want him safe. I'm sure the judge wants him safe, and I know you guys do. It's just a question of figuring out how do we do that.